the other lawyer was trying to just ask me the dumbest questions, but they were like so easy. I don't know if this guy thought he had like some crazy shit up his sleeve. He's like, didn't you, is it true that you directed your fans to Kiwi Farms by posting about it publicly? But then later on, the judge asked, well, wait, didn't plaintiff also post about it publicly? It's like, yes, thank you. Yes, they did.
Thank you, Mr. Bonnell. Do you go by any other names? Oh, they don't write like what happens in the courtroom, but it was really funny. So I stand up, and it's kind of weird because like every time I'm moving in this courtroom, there's like wind blowing, so my hair is slightly ruffling. The jacket, my very nice and expensive suit, I button as I stand up. It's kind of a little bit billowing behind me. And I cross the stand. Initially, their lawyer was standing there, and he drops his pen. I bend over very gracefully when I go to pick it up and hand it to him. He tries to bend over, and his glasses fall off, and he's like shaking. And I'm like, did you drop your pen, Mr. Lage? And he's like, yeah. And then eventually he takes
I hope Pxie wins this lawsuit.
it, and then he tries to go back to his desk, but he goes to the wrong one because he's so starstruck. I'm just kidding. I'm making all this up. Okay. All right. Okay. Thank you, Mr. Bonnell. Do you go by any other names? No, my online handle is Destiny. Okay, and your online handle is Destiny. What? Who is Destiny? It's basically just me doing politics, philosophy, and video games. Okay, and could you explain to the court what you mean by doing politics, philosophy, and video games? Are you an online streamer? Correct. It's like YouTube videos, but you're posting them live, basically. And do you know the plaintiff in this case? Yes. How do you know the plaintiff? She reached out to me after we did a Twitch debate panel, maybe 5 years ago, I think in 2020, and we began chatting from there. And did you and the plaintiff develop an online friendship? Yes. At any point during your online friendship with plaintiff, did your conversations turn to a sexual nature? Yes. And at what point did they turn to a sexual nature? I don't recall exactly, pretty soon, maybe a few months after talking. And when you agreed that they turned into a sexual nature, how would you characterize that? What do you mean by the conversation turned sexual in nature? I think it began chatting, topics get a bit racier, maybe conversations about current partners and then sexual activity, and then it kind of tends in that direction. Was there a time when you would ask the plaintiff if she was interested in watching sexually explicit videos of you? Yes, I believe so. And was there a time when plaintiff asked you if you were interested in watching sexually explicit videos of her? Yes. And did you, in fact, exchange sexually explicit videos of each other with the plaintiff? Did you, and then I say of each other, as in me and her, or, and then he said, I asked a bad question. Did you exchange videos of yourself with plaintiff of a sexual nature? I say yes. This is my lawyer right now. Direct examination is my lawyer. And did she exchange videos of herself of a sexual nature with you? Yes. And was there ever any discussion prior to exchanging those videos on who you were allowed to send the videos to, or who she was allowed to send the videos to? Her lawyer objects. Your Honor, objection. Understanding that this is an injunction hearing, and this is his witness, he's asking leading questions throughout the testimony, understanding the nature of the hearing. The judge says, I don't think they're leading. Overruled by Mr. Butler. You can answer, Stephen. I say, I'm sorry, can you restate the question? Yes, was there a time when, I'm sorry, the question was there ever any rules on who these videos could be shared with? And I said, if those conversations occurred, it would have been in person, and it would have been 5 years ago. I can't recall the specifics of those conversations. Do you recall telling the plaintiff that you intended to share the videos with your then fiance? Well, I can't recall that explicitly. It certainly would have come up. There's no world where my fiance would allow me to send videos of me and her to another person, and if I recorded something with the other person, to not share those videos with her, of course. He says, and do you recall the plaintiff telling you that her sexual partners would be seeing videos that you sent her? I said, again, I don't believe that we ever explicitly mentioned that. It probably would have been assumed based on our conversations. In 2022, did you come to meet someone online named Rose? I said, if by meet online, you mean digitally talk to each other? Yes, yeah. Before you get there, and then the judge stops and he says, before you get there, how long did you have any sexual relations with the plaintiff? And then I said, before I communicated with the party in 2022, I believe me and plaintiff, recorded in, let me understand. When you say any sexual relations, do you mean conversations or in real life? I asked for clarification. The judge says in real life. And then I say, I believe it's in the record, but I think the plaintiff, I want to say had just turned 21 when we did. So whatever math is, maybe 2021, I think was the date on that. The judge says, and how long did you have a sexual relationship in real life with her? I said, in real life, we only met sexually one time. The judge said, okay. I say, we continued sexual conversations after, but we only had one sexual encounter. The judge says, you only had one encounter? I say, correct. He says, okay. Andrew says, yeah, let me back up. I did jump ahead a bit. Did you at some point decide to make videos, sexually explicit videos with plaintiff? I said, with her? Yes, yeah. Okay, and was that in, approximately March of 2020? I said, that sounds right. Do you recall whose idea it was to make sexually explicit videos? I believe it was her suggestion. And did you arrange to meet with plaintiff in person to actually record a video together? I said, among other things, yes. And do you recall approximately when you met plaintiff to record the explicit video? I said, probably sometime after July of 2020. I don't recall the exact date. Would September 6, 2020 sound about right? That would, yeah. And during that meeting, firstly, where did you meet to record this video? I can't recall exactly where it was, but the place that we met initially, we met for dinner with two friends of mine. So it must have been in Florida, maybe Miami, I guess. Okay, and at the time, were you married? I said, I don't believe I was married. I think we were engaged to be married, though. My wife was from Europe, so... And then the judge says, your wife was a what? And I said, she was from Europe, Swedish. The judge said, oh, from Europe. I said, yep. He said, got it. I said, so the marriage process was a kind of convoluted for a bit, yeah. And then Andrew says, and did you in fact record a sexually explicit video with the plaintiff in September of 2020? Multiple, yes. And when you say multiple, what do these videos depict? Generally, we're not asking for details. I said, 2 of us engaged in a one-on-one sexual encounter. He said, and the encounter was entirely consensual. I said, yes. In early 2022, do you recall receiving an online message from a woman named Rose on Discord? Yes. When you say a woman named, that was her screen name, yes. Screen name Rose, and as best you can describe, who is Rose? As an online content creator, a lot of people reached out to me, kind of like plaintiff, through different platforms. This is a person who initially sent messages to me on Twitter. At the time it was called, now X. It was just a person who reached out who seemed to engage in some kind of sex work on X. And then she reached out to me and personally messaged me on that platform, and then we switched to Discord. And did Rose send you sexually explicit videos over Discord or any other online means? Yes. And did you send Rose sexually explicit videos of yourself? Yes. And was one of the videos that you shared with Rose a copy of the video that you made with plaintiff? Yes, although Rose didn't know who plaintiff was at that time. And did you not identify plaintiff in that video by her screen name, correct? By any name, no. And do you recall approximately the date that you transmitted the message to Rose containing the sexually explicit video? I believe it would have been April 9th or April 10th on 2022. Okay. And you understand that there has been some testimony today about whether or not the date format that's reflected in the transmission documents was in the European format or the United States format. I'm aware there's testimony concerning that, yes. And how are you certain that the transmission of the video took place in April, on April 9th or 10th, and not October 4th or so? I said, there are multiple ways. One is I have a backup of all of my messages with this person. A second way is that those messages still exist on Discord from that person in the date of April. The third way would be that when those logs are posted, that are supposedly in contention, the timestamp at the bottom is written in a time zone that is European. And the fourth way would be that that same European time zone is referenced by, I believe, the person who posted those on the aforementioned website, Kiwi Farms. Question. And since April 9th, 2022, or let's say April 10th in 2022 in Europe at 1 o'clock in the morning, had you transmitted the video to Rose or to anyone else?
Was Lauren Voss her first boyfriend? No.
To the best of your knowledge. No.
An
You're aware the
unknown
plaintiff claims
first
that
boyfriend.
approximately 15 witnesses contacted her, claiming to have evidence that you shared the video with them. Are you aware of this? I feel like I've seen conflicting statements about whether it's the video in the complaint or just other videos that aren't the subject of this complaint, but I've seen this, yeah. And have you sent the videos of yourself and the plaintiff to anyone apart from Rose? Let me stop there. To anyone apart from Rose. And I said, maybe my ex-wife. We might have watched it in person, but it would have been after the videos were recorded, so... And then Andrew says, so none of those 15 potential witnesses that plaintiff has identified, however they've identified them, certainly not by name, you've never sent a video to any of those 15 people. I don't think so. I'm only uncomfortable because the 15 names haven't been made available to me. So say, for instance, my ex-wife was one of those 15, then in 2020 after recorded, maybe, but to my knowledge, no, to the best of my knowledge. Now keep in mind, because they think that this is all a fucking game or whatever, they've never handed any of these names over to us. They're supposed to. Federal Rules of Civil Procedure evidence handling, they're supposed to, but they've never made any of that available to us. So it could be that like, if Pxie was like one of those 15 people, then like, oh, well, fuck me, I guess you got me, LOL trapped, but yeah. And then Andrew says, apart from your ex-wife, and then the judge says, how do you know though? And then I ask, how do I know what? And the judge says that you didn't send the videos to others. And I said, yeah, you want me to explain that? And the judge says, yes. So I said, so after plaintiff made her public acknowledgement that she was going to file the lawsuit against me, I became aware that I had an obligation to preserve evidence for this case. So the first thing I did was online platforms allow you to request a copy of all the messages that you sent, I think as a result of the GDPR in Europe. And once I made that request from all the platforms that I chatted on, I did a search through all of my messages to see if I had sent either the Google Drive link or that video, or if there were references to that video from anybody else that I messaged, and I couldn't find any references to it at all. The court. At the time that you sent the video, had you met this person, Rose? I said, no, I had not. The judge says, okay, so prior to that, had you sent sexual related videos of others to other people? I said, yeah, plaintiff would be one of them, yeah. And the judge said, all right, so this wasn't the, I don't know if I'm still talking or we're back and forth. I try never to interrupt the judge on things, but I say, well, let me be very clear. I'm so sorry. For sexual videos of other people, every sexual video that I send is involving me. So there might be another person in the video, but it's not just videos of others. Oh, for like half of you guys that are like normies and not Coomer online people, this might seem irrelevant, but one thing that I really don't like is a lot of people, Pxie included, keep trying to make it sound like I'm sending like just nudes of her or videos of her or other people to other people. Like every single thing that I've ever sent or shared with people, it's always of me. Like there might be another person, but it's my stuff. I'm only saying this because like, some people maybe it seems the same, but others like one is like substantially weirder. Like why are you sending just videos of another person to another person? That's kind of weird. But the other's like, well, obviously I'm only sending content that involves me, right? But okay. The judge says, right. In other words, of yes, sexual videos that you created. I say yes, and the judge says, you sent them to other people before. I said yes. And the judge says, and when you do that, do you normally get consent from somebody or not get consent? And I said, so I would say that we generally have conversations at the time of the recording. People will express varying levels of comfort about material existing. If somebody's very uncomfortable, then we typically just won't record anything. Other people have experience recording stuff. I would say generally, if asked, maybe I could reproduce some of these conversations. I could go back and check, but usually the conversation would be like, hey, well, if you send it to anybody, just make sure it doesn't leak, haha. It's usually that kind of conversation. The judge says, at the time that you sent the April 9th video, that you're saying is April 9th, you knew it was a video of you and the plaintiff. I said yes. And the judge said, and why didn't you communicate with the plaintiff that you were intending to do that? And I said, I mean, we both, or I won't speak for the plaintiff. I just have a lot of videos that I've recorded with people in the past who've also recorded videos of me. And I would argue it's kind of a norm that we just kind of trade stuff around, basically. The judge says, so you thought you had some kind of implied consent? Is that what you're saying? Funnily enough, the judge is the one that first brings this term up. And I say, yeah, basically. I mean, if they sent me videos of them and other people, I've sent myself videos with other people. I don't believe in any of the conversations I've had, for instance, with plaintiff. I don't think there was ever an explicit ask. I don't believe she ever asked me. I don't believe she asked me at the time if she could send it to her boyfriend at the time. But I wouldn't have objected because my understanding was basically that that's what we're doing this for. Yeah. And the judge said, I see. And then did you consider redacting the image of her face? Did that come up in your mind? And I said, it didn't at the time. I'm not the best at like video editing per se. Like I'm like a presenter, so that would have been beyond my technical hurdle, I guess. The judge says, but you're aware that you can do that. And I said, yeah. I would say just on my personal level, if I was at the point where I was trying to redact parts of the video, I would be uncomfortable sending the video at all because there are always other ways of identifying people, whether through an identifying mark or something. So in this case, when you sent the April 9th video, you weren't concerned about
That makes sense. Why send the video at all if you're ever worried about like the face being revealed or anything like that, right? If you're worried about it leaking, then you wouldn't have sent it in the first place. Otherwise, you're arguing for a circumstance where you want to send the video, but you're like censoring the part that would be identifying, right? Which would make minimal sense considering how someone is not holding a gun to your head and telling you to go send the video. Unless, what if that is true and someone is holding a gun to Steven's head when they're trying to get Steven to send the video, and that's why he has no choice. Absolute cinema.
that. No, the person at the time had already shared explicit material with me. I have never had anybody leak a bunch of my private explicit material before. This other person was also kind of like a sex worker person. Usually they're pretty clear about that stuff. Like it doesn't just happen, it would ruin their business, so ... Okay. And then my lawyer asks me, Andrew's back to asking questions. Would you say, Mr. Bunnell, that it's common among your community or your fans to trade sexually explicit material with each other? I say, I would say it's common in certain circles. He says, in what circles? I say, I would say it's common in certain circles. My community can be quite broad, so I wouldn't generalize everybody that way, but there are groups of people who trade a lot. So everybody that I believe is referenced in this case traded multiple...
Either you have permission or you don't. Sure, but that's a huge generalization though, right? Like if people said consent was simple, we wouldn't have so much like court cases and shit going through it in detail, right?
circles.
Yeah.
I would say it's common in certain circles. My community can be quite broad,
trust me.
so I wouldn't generalize everybody that way, but there are groups of people who trade a lot. So everybody that I
Consent
believe is
is almost
referenced in
never
this
simple.
case traded multiple explicit material back and forth. Would plaintiff be in that circle? I know for a fact that plaintiff has sent me videos with at least one person and offered with at least others, but I don't know. I don't have copies of those videos anymore, so I can't go back and check if it was always the same person. I don't recall that. And there was testimony about a woman receiving your video named Abby MC. Do you recall that testimony? I recall that declaration, yes. And the testimony today about the fact that Miss MC Abby MC testified in her declaration that she received your video after October of 2022. Do you
Shaz, who's a bigger gooner between you and Destiny? Dude, are you kidding me? Do you even need to ask? Definitely Destiny. What the fuck? Don't ever imply that ever again, okay? I'm kidding, joking, I love you. But like, dude, I probably jerk off like once every week, okay? Like, don't most men jerk off once a day? Or jerk off like 3 times a week or something? I feel like even women fucking finger themselves more often than I do that. What the fuck? Yeah, I'm a prude. What do you want me to say?
have any response to that? So again, as I stated earlier, I made a copy of all my online conversations. When that person initially referenced me sending them explicit material, I went back and I checked my
6 days, maybe 5 days. Like, there have been times where I jerked off 2 days in a row, but like, those times are not that common, okay? Like, seriously, okay? It's like, oh yeah, if something is horny enough, but that's like occasional, you know? What day was the last time? I don't fucking know. You're not entitled to these details. Fuck you.
archive of the conversations that we had with each other. And when we had a back and forth, the conversation was pertaining to a pair of videos that were never at all related to
Weirdo.
plaintiff. I know
I already told you more than enough. Weirdo.
the date she's referencing. I have my messages from that day. If plaintiffs request the discovery, I could provide those messages. But yeah, it was not the video involving plaintiff. You have never sent the video involving plaintiff to anyone after October of 2022, correct? No. Or correct, yeah. Double negative. One of the questions that I wanted to ask you today was, what steps did you take after plaintiff alerted you to the fact that her video or your videos had been published online? What steps did you take to prevent the dissemination of that video?
You may have low T. Yeah, that's a good thing.
So, unfortunately, being a public figure, once something is out there, the way you deal with it is you have to be very careful because there's a thing called the Streisand effect, whereby aggressively going after material, you end up publicizing it even more. So I was in collaboration with plaintiff to figure out, like, how do you want me to report these? Do I make any of this public? The steps that I took were generally emailing websites using a combination of, a DMCA request for one, which is a Digital Rights Act saying, I have the copyright of this video, please take it down. And then I had an assistant working, sending an email to Kiwi Farms, letting them know that this was revenge porn posted without my consent. I don't believe either of those two circumstances were helpful, but this is why I was pursuing. I had another litigation from New York that I was hoping to get an injunction or something that would allow me to come with a stronger tool. And tell me about that. You hired a firm in New York to do what? Well, initially, the goal was to unmask and uncover the person who publicly published all the material and potentially to explore going after Kiwi Farms because the owner of that website was knowingly hosting material that he knew was a revenge point of me and then publicizing it, making it available to everybody. Andrew said, give me one moment, Your Honor. Your Honor, I will reserve the remainder of my time for redirect. Thank you, and then cross-examination. Oh, so Andrew reviews his notes, sees if there's anything else I wanted to ask. He doesn't find anything, so he says, okay. So now this is cross, so her lawyer is coming up to ask me questions. So her lawyer comes up. You're aware that you're opposing the court issuing the order to Kiwi Farms to take down the videos of you and Miss Doe, correct? Yes. It seems to kind of fly in the face of your stated intent to want that video off the internet, correct, sir? No. No? You think those positions are consistent with one another, correct? Absolutely. Okay, why? My understanding is that a court order would only remove the videos temporarily. The videos could just be reposted. I don't believe the court order could make any statements about future behavior. I saw a ton of other explicit material that was posted on that website and across the internet, and none of that material was requested to be taken down at all. If anything, I believe that just those videos being taken down might even exacerbate public postings of plaintiff's own video because people would see that she's the only one being removed. And I don't even know if you're going to and I don't even know if you're going to issue court orders to non-parties to cases. Although I really wish that some other parties were involved in this case. By the way, all of this
Yes. Yeah.
This was the foundational rationale for why the judge dismissed their court orders. Because Kiwi Farms is a non-party to the case, and because they weren't really wanting to issue a court order, they were issuing an injunction that was disguised as a court order. And they're not a party to this case. An injunction would have been an improper remedy for what they were looking for, and they didn't even really phrase it well. So, get smacked down, okay? Her lawyer says,
what the
that other
fuck?
party that you wish was involved in the case is somebody that you had contacted, correct? Can you remind me at what point in time this transcript? This was in June, like June 3rd, okay? So this was months ago, 4 months ago, I think. 4 or 5 months ago almost. So her lawyer asks me, that other party that you wish was involved in this case is somebody you had contacted, correct? Rose? I said, potentially. He said, okay. Are you aware that the operator of Kiwi Farms is an individual by the name of Noel, or goes by the handle of Noel? I said, is his online name? Yes. Okay. And then he says, may I publish, Your Honor? Sure. And then he tries to DM ambush me. I think he has stuff on like a screen, what do you call it? A projector or whatever. Then he asked, do you see that on your screen? I said, it's kind of cut off. The judge says, the zoom is on the top button. There you go. He says, can you see it now, sir? And I say, okay, correct. And he says, okay. So, they have...
Destiny feeling victorious right now? Yeah, I can't wait until I crush his expectations by betraying him.
He has so many dumb lines of questioning. Oh my God. He said, okay, so you disagree with the statement from the operator of Kiwi Farms that you had made no effort for attorneys to have them take down the video? And I said, I don't contest that statement. There are other parties besides attorneys that could contact him to take the video down, but... And then he says, but you indicated that you had hired a firm to do so during your testimony here today. Did you not, sir? And I said, yes, but I testified that the person that contacted Kiwi Farms was my assistant, not my law firm. The law firm that I retained had a lot of experience with Kiwi Farms and didn't think it would be a good idea to pursue that without an actual case. And then he says, so instead of using legal avenues, you sent your assistant to do it instead, even though you hired this New York law firm, correct? Andrew says, objection, argumentative. The judge said, overruled. I said, I'm sorry, could you restate the question? He said, sure. And then the judge says, the question is, you used an assistant, your personal assistant of yours, to do this as opposed to hiring a law firm. And I say, I don't like the phrasing opposed to. I did use my assistant initially, yes, because the legal process is slow, unfortunately, and this is a pressing issue. So I contacted using the means I had available to me initially, and then was pursuing a legal case in the back of that. And then her lawyer says, okay, in the legal case in the back of that, did you file any motions or file any pleadings to have Kiwi Farms take down this video at any time? And I said, we hadn't even been able to file the case yet before plaintiff made a public statement to file a case against me. Public statement? Well, have you filed anything against Kiwi Farms? I said, not yet, no. And he said, okay. And then the judge asked me, did you not tell the plaintiff when she first contacted you that you would do that? What did you tell the plaintiff when she first contacted you? And then I said, so if requested, I could produce an exact copy of those messages, but I believe it was something along the lines of, I'm in contact with law firms, and I'm trying to get basically somebody to pursue this case so that I can get a strong, basically an injunction to get this material removed, and it would not be published on the internet. And the judge said, okay, and did you in fact do that? And I said, did I do what? The judge said, what you told her, did you do that? And I said, yeah, there were a couple of law firms that I went through initially that were kind of uncomfortable with the subject matter of the case. And then eventually I was referred to a really good law firm in New York. And then we had basically finished and were ready to file an anonymous suit against that process was there, but then plaintiff filed her lawsuit. And there's the law firm in New York typically does plaintiff work and not defense work. And so it's kind of an awkward.
I hope that confirms, like, the packet did actually exist. right? And Steven wasn't lying about the packet. I mean, in addition to me actually seeing the packet against Solo, like I really doubt that Steven would lie in court like this, obviously, right? About the packet or whatnot. But yeah, no, the packet is the thing, okay? That was meant to go after Solo before Pxie upended everything. But
maneuvering of that situation, if that makes sense. The judge says, okay. And then her lawyer asks me, so it would be fair to say that you, as of today's date, have not filed an injunction to take down the videos involving you and Pxie, correct? I said, correct. He said, all right. There was a lot, I think he shovels his papers at this point, and then he moves on to his next points. All right. There was a lot of questioning of Miss Doe about your interactions prior to your sexual encounter and what the parameters of that were going to be, correct? You heard that testimony? I said, I heard testimony that we had a lot of conversations about consent broadly, about what our sexual encounter would be. I believe we did discuss that, yeah. He said, all right. I'm going to show you a text message between you and her from February 26, 2020 at 11:20 p.m. and ask if you recognize this. Do you see it, sir? I said, yes. I'll say it's not a text message. It's a Discord message, but I understand, yes. And he says, okay. And in this is Miss Doe telling you what the parameters that she's expecting of your sexual encounter and your ability to discuss it or disseminate information about that sexual encounter with third parties. And I said, I'm sorry, could you restate the question? I said, sure. And then the judge intervenes. He says, what was your understanding of what this message was about? And I said, yeah. So the reason why I'm uncomfortable answering is this message, this conversation was, I believe, occurring at a time when there were people publicly fighting over who had hooked up with who. And this message basically had to do with, does anybody know that we've hooked up, or did anybody know that we had a sexual encounter? This isn't about explicitly transmitting material or anything like that. This is just, does anybody in our community know that we hooked up before or had a sexual encounter before? So one of the things that they're trying to do is they're trying to say that Pxie me, typically I used to do this with every girl. Now I think I just don't, I don't mess with streamers, YouTubers, or internet people, fuck that, sexually. But the agreement, Pxie was always like, don't tell anybody we hooked up because she doesn't want it to like undermine her online cred or whatever. But that's all that was. It had nothing to do with like, you know, trading any material with anybody. Obviously I couldn't send this to somebody in our communities because obviously then people would know. But yeah, this idea that she keeps trying to go back to this, well, we said don't tell everybody that we hooked up, so that means you also couldn't have sent any of our stuff to anybody ever. It's like, well, that's not really the same thing. But yeah, they keep trying to.
oh yeah, I believe that she was lying to the internet, right? Like she said, oh yeah, I want to be known as the one girl that has essentially become like more well known in this space because I wasn't hooking up with a streamer. Oh my god. So she was like lying about that too. Like she was because I remember her online tag or whatever the fuck was supposedly, oh yeah, the one girl that made it all on her own without any help from a male streamer or something like that. Oh my god. Like in retrospect, it's just also cringe. Like it's just so and that's like the most egotistical thing ever. Like yeah.
To carry this legal
So
theory around,
stupid.
whatever.
Fuck.
Oh,
me.
and also she was fighting with Lav at the time, right? Okay. So he says, well, sir, you see here where it says, don't worry, I totally trust you. And you've been very clear with how seriously you take consent. And I also feel that you've been very honest with me, so I trust you in your words. What is that in reference to, sir? And I said, a reference to whether or not I had been gossiping about us having hooked up before. Well, what does consent have to do with that? Well, whether or not you would consent to me telling somebody we hooked up before. Okay, so she's not consenting to you telling people about hooking up before. You think she's consenting implicitly or giving you implied consent to share, intimate videos of her with you or with third parties? I said, I don't believe that the person who I contacted, they had no idea who the plaintiff was. I didn't identify the plaintiff in any way, size, shape, or form. This was 3 years ago, so apparently that person didn't say anything about that at the time, and nobody at the time had known that we hooked up. So insofar as me maintaining our, I guess, anonymity about our sexual encounter, that seemed to be true, as far as I was aware. And I said, to the best of my knowledge, when I messaged her, and I believe that was
girl
true.
boss.
Prior to sharing the sexually explicit video of you and Miss Doe with Rose, did you contact Miss Doe and ask her for consent prior to sharing it? If we had a conversation, it would have been in person when we recorded it. Okay, no subsequent conversation? Not that I'm aware of, no. You were still in contact with her, though, at the time that you sent the video to Rose. You were in contact with Miss Doe still, correct? I'm not entirely sure. We were still friends on Discord, but there were times where she might have been, I think she took like a medical absence to, I don't know if she was pursuing school or relationships, so we weren't really talking as regularly. But I don't recall the exact dates of that. But you may.
I just don't understand if she wanted this image, why she hooked up with him at all. He can't be that irresistible. Well, I don't know if she made that label like before or afterwards. I mean, either way, like, I think we would be lying to ourselves if women weren't attracted to wealth and status. I think it's just a fact at this point that women are just attracted to wealth and status. Yeah. Especially younger women. Yeah, especially younger women are attracted to wealth and status. Older women know better. It's just like how men earlier on are only attracted by looks, but not really like getting to know the person and loving them for who they are. Like they just don't know anything about that. Yeah, younger love is pretty immature.
Made no effort to tell her, look, I'm thinking of sharing your video with this third party. Are you okay with it? Correct. And you took no efforts to hide her identity on that video, did you? I had no reason to believe the other person knew who the person was. I didn't identify her at all, so, well, was Jane Doe's face visible? Oh, wait, hold on. Tux? Well, was Jane Doe's face visible in the video? Yes, and Jane Doe had appeared on your podcast previously on your stream, quite a while ago. Okay, and her face was visible at the time? Yes. In your streaming, have you ever stated to your audience that posting explicit material... Oh, and then I think he shuffles his papers again here, and then he goes to a different line of questioning. In your streaming, have you ever stated to your audience that posting explicit materials is one of the worst things you can do to an individual? I said it would have been with more qualifiers, but probably. And have you ever stated that there's no secrets in the streaming world? I imagine so, yes. After this lawsuit was filed, have you ever made the statement while streaming, after today, her public reputation will be finished? After the lawsuit was filed? Correct. He asks me, there's this cross-examination, so her attorney's talking to me. After this lawsuit was filed, have you ever made the statement while streaming, after today, her public reputation will be finished? I said, after the lawsuit was filed? He said, correct. I said, like immediately after, or? He said, shortly after, at any time. And I said, I don't recall. He said, you've never made any kind of statement to that effect? My lawyer says objection, asked and answered. The judge has overruled. I said, I don't recall. I stream every day, 8 hours a day. I make a lot of statements in a lot of different areas, so, okay, and a lot of areas includes discussions about this particular case, correct?
Nice meme.
I said, correct. All right, and you make money off of your streams, correct? Well, yes, correct. So you're actually monetizing this lawsuit by virtue of the streaming that you do relating to this case. Do you not? I said, narrowly, yes. Broadly, no. I've lost far more than I've gained from covering the public filings. And then he shovels his papers for a bit. He asks for a moment. Just a moment, Your Honor. And then he redirects a different line of questioning. Have you had other individuals claim that you have shared their videos, their sexually explicit videos, without their consent? And then I asked, do I need to answer that? Is that relevant to this? And I think the judge, there's no thing here, but I think the judge says yes. And then he asks how many. And I said, I can't recall off the top of my head. He says, okay, more than 5. I said, I don't believe so. He said, less. So other than Miss Doe, it's less than 5. How many? And I said, the nature of my work and the nature of the world that I exist in, a lot of people make a lot of claims at different points in time. Some change, some come and go, so I don't want to speculate. Okay, you met Abby MC in approximately 2023, did you not? It sounds correct. All right, you had a sexual relationship with Abby MC, correct? Correct. All right, you're aware that Abby MC is indicating that you shared the video of you and Pxie with Abby MC in 2023, correct? I'm aware of her saying that, yes. And then the judge says, well, do you recall doing that? And I said, no. The judge says, I'll rephrase the question. Did you in fact share the video of the plaintiff with this Abby person in 2023? I said, no. Like I said, I went back and dumped my messages and I can read everything I sent to that person prior, so. And then her lawyer says, of the videos that were posted to Kiwi Farms, how many videos were posted? I said, unfortunately, I don't know. I think it was in excess of 25 plus. And then her lawyer stupidly asks, had you had consent from all those other 24 individuals to share their videos with Rose? And I said, 24 individuals? And he said, those 24 individuals that you had relationships with. And I said, the majority of the content posted on Kiwi Farms were solo videos featuring only me. I believe it was only, I might want to say 6-ish videos or maybe 5 videos, 5 or 6 maybe of involving other people. And I don't think it's 5 or 6 unique individuals. I think overall, I think it was 3 or 4 other individuals. So, and then he says, one of those 3 or 4 individuals, did you have consent to each and every one of them to post those videos? I said, publicly, no. To share them with other people, I would say yes. You would say yes? Yes. Are any of those 3 or 4 individuals, any of the other individuals that are making claims against you for having shared their videos without their consent, and I'm talking about other than Miss Doe, Andrew says, objection, there are no other claims, Your Honor. There's one plaintiff in this case. The judge says, I didn't understand your question. And then her lawyer says, let me ask you this question. Did you post them on that, what is it called? Again, Kiwi Farms? Or the judge is asking me this, I think. I said, it's called Kiwi Farms. And the judge says, Kiwi Farms, did you post those videos? And I said, absolutely not. And then he says, okay, do you know who posted the videos? I said, if you'd like, I can speculate, but I don't know, unfortunately. And the judge says, you don't know the answer? And I said, I have an idea, but it was whoever had access to
Because they're anonymized. But I mean, it's just solo.
to the account that I was initially conversating with. I think a different person gained access to that account, scrolled up, saw a bunch of messages, and then decided to, well, first they tried to blackmail me, and then they dumped all of the material onto Kiwi Farms. And then the judge says, I see. And then her lawyer says, however, you have directed your followers to those videos on Kiwi Farms, correct? And I said, what do you mean when you say directed? And he said, okay, you streamed or written about the existence of those videos on Kiwi Farms and indicated that the video of you and Pxie is available on Kiwi Farms, correct? And I said, I don't like the framing, but I have complained that my content was still being hosted there, yes, and nothing was being done about it, despite all the people talking about it, yes. And then the judge asks me, now, when is the first time that you found out about this Kiwi Farms postings? And I said, I believe I was in the shower, and I think I got a text message from plaintiff. And the judge says, so that November 28th or 29th event is the first time that you found out about it? And I said, that all of my explicit material had been leaked? Yes. And the judge said, right, okay. And then her lawyer says,
Wait, how did you find out in the shower? What? Were you on your phone in the shower?
when you were contacted by Miss Doe, did you in fact tell her, look, I'm sorry, there's no excuse for this? And I said, that's part of my message to her, yes. And he said, all right, you've since deleted some of those messages, have you not? And I said, from Discord, yes, although I preserved copies of them for my records. During one of your live streams after this case was initiated, you published Jane Doe's name, did you not? And I said, I believe it was the same day. I think there was a filing for the protective order for I believe on the 19th, I think. So the answer is yes. And I said, can you restate the question? He said, yes, you posted or made available through streaming Miss Doe's real name, correct? I said, her first name, yes. If I can add, after I was made aware that the protective order had been filed, under advice, I removed the reference to her name on that YouTube video, though. He said, you don't have anything in writing wherein Jane Doe consents to you sharing explicit material of her with you, correct? And I said, correct. Of us to other people? Yes, correct. Then the judge says, now let me ask this question. One of the arguments for the motion is that based upon what has transpired, there's still a risk that you're either disseminating or not actively removing her videos from the internet. What's your response to that? And I said, so I think if we were to go through the declarations, I think plain text reading in the declarations, it's obvious they're not referring to those videos. So it's a declaration on the record by Hannah Brooke where I'm speaking about performing a certain sexual act. There's not a video that has anything to do with the plaintiff, although they've provided that. Wait, does that make sense? There's not having anything to do with the plaintiff, although they've provided that. They've stated that? Maybe that's supposed to be a different word. I don't know. The only evidence in the record so far, there's other evidence mentioning other people, but in terms of the video that's the subject matter of the complaint, the only evidence in the record is with the ABMC person, and that's them claiming that I sent them 2 videos. So one person of which I've never even taken videos with. So just to be clear, this Hannah Brooke person tried to like honeypot me, where they started talking very sexually with me, and then they tried to lie about like the videos that I was sending them or offering to send them. I wasn't even offering to send them. I was joking about them being up on Kiwi Farms.
What?
But like by the way that I'm talking, it's obvious that I'm not talking about anything having to do with me and Pxie. Although they lie about this multiple
That's so gay.
times, and they've stuck this in there.
I put my phone on full blast for the podcast. That's different. That's different. Because it sounds like Steven was looking at Kiwi Farms in the shower. Or he checked his Discord in the shower. That's different.
Thing multiple times. I think they finally dropped that. I don't know if they're still carrying that on. But the judge also noticed this when he made the rulings on the preliminary injunction, thank God, that whatever I'm talking about with Hannah is not the same video in this complaint. So this is all just a lie that they're throwing shit up on to see what sticks, I guess, or whatever. The Hannah person is such a fucking schizo. She's always in the comments on the sex tourist fake lawyer guy's videos. If that's true, that's funny. This is a person that I talked with non-sexually for like a year and a half. Apparently she used to have like a heroin addiction, or still does, and she only got sexual or like hinted at sexual stuff with me after this lawsuit, I think, was filed, or after Pxie made her Substack. And I guess it was to try to honeypot like some statement out of me that she immediately ran to Jiskill's Discord server with, and then took to Pxie to try to fill a declaration over. But it's not. It doesn't say what they wanted to say. It's just really ridiculous. And she deleted parts of her messages to me before she pasted them, which is even funnier. Like where she calls like Merc crazy and shit because she didn't want to look like she wasn't like supporting her queens, but cringe and stupid and perjury. But whatever. And the judge says, and when did that supposedly occur? And I said, I believe, when did the declarant testify that occurred? And the judge said, no, when did you supposedly send the videos? And I said, I think that she claimed sometime in 2023. And then the judge says, okay. And then in terms of you are not doing enough to remove her video from the internet, what's your response to that? And then I respond, so there's 2 parts. So the first part is that I don't know exactly when, but several years ago, a lot of large pornographic websites like Pornhub and everything, there were new federal laws that made it very strict about who could upload materials onto those sites. So as a result of that, the only websites now that host explicit material don't seem to respond much, unfortunately, to emails. So for one website, I tried to email the website itself, then I tried to email the hosting provider, like the internet company that hosts the website, and I got no response. For the main distribution center, which is Kiwi Farms, I said that I had my assistant send a message to the owner of that website, online, his name is Noel, and he reposted that, actually, I think a week ago, making fun of me because that guy had a personally bad relationship with me. So it's hard for me I can't really do anything to take anything down on Kiwi Farms.
I can't believe Noel complains about how toxic his site is all the time. Like, you've got to be fucking kidding me. Like, you're leaking DMs, like, making fun of people who are trying to take down sexually explicit material or something like that. But then, like, on the other hand, like, you want to, like, I don't know, you want to reveal it because you fucking hate the person. I mean, fine, but then just don't go around bitching on live stream on kick.com, all right? Fucking mad at the internet. Like, that's his fucking handle, by the way. Noel's Joshua Moon's fucking handle. Like, don't go around bitching like that when you cultivate the audience, right? Like, what the fuck? You're the owner of Kiwi Farms. You're the owner of Kiwi. You're the cultivator of your fucking audience, mate. You're a fucking moron. You are remedial. You are a retard, okay? Like, you are one of the most retarded people ever. Okay? Like, it's not even close, actually. Yeah, if you participate as a toxic site owner, and you enable them to do what they do, stop complaining about how toxic they are, moron.
I have no power over any of these
To Kiwi Farms evolved from 4chan? Yeah.
other platforms. All I can do is file.
It evolved from originally being a low-cal tracking thing for Chris Chan, but then afterwards everyone just began tracking everything, so it's like whatever.
A DMCA request, and then if they've got a form for revenge porn, fill that out. But all the reputable online porn sites don't host stuff like that anyway, unfortunately. And then the judge asks her attorney, any further questions? And then he says, yes. And then he asks me, so you made IBMC sometime in 2023, right? And I said, it sounds right, yeah. He says, all right, so the video would have been shared sometime in 2023, if that's a video you shared with her, correct? My lawyer said, objection, calls for speculation. It assumes facts, not in evidence. The judge says, overruled, you can answer if you know. And I said, I don't actually have to speculate because I believe in the declaration, Abby referenced a specific date for when I transmitted the video. I have logs from that date. I did not transmit the video on that date. So, and the lawyer says, okay, that's not my question, sir. My question to you is, if there was a video transmission of the explicit video between you and Ms. Doe, it makes sense that if you shared it with ABMC, it would have to be sometime in 2023 because that's when you first met ABMC, correct? I said, no, not necessarily. We could have transmitted it before meeting each other in real life. Okay. But you do have record of having sent her explicit, and then the judge stops and says, well, let me ask you this question. Do you have a specific recollection of transmitting some video to her? And I said, I don't personally have like a specific recollection mentally, but I have logs from that. And the judge said, I understand. And I said, correct, yeah. And the judge said, in terms of your recollection right now, you have no recollection of sending that video to her? And I said, no. And then her lawyer asked me, do you have a recollection of sending her videos that were explicit in nature? And I said, yes. And he said, now, we had talked previously about others complaining that you had shared their videos without their consent. Is there an individual that goes by the name of Cherry that has made a complaint that you shared her explicit video without her consent? Andrew says, objection, lacks foundation, lacks relevance. The judge says, overruled. And then the judge asks, how do you spell that? Or maybe the court reporter asks, how do you spell that? And then her attorney says, Chairy. It's a screen name. And then Mr. Leitch says, you can answer, sir. And then I said, I'm aware that she's made public statements like that. Yes. And he said, all right, you have a Google Drive with the content of your sexually explicit videos, correct? And I said, kind of, although the phrasing of that is strange. They're trying to, one of the arguments too that they were running with legally, when I'm clarifying here is because I know what they're trying to like be vague or ambiguous about. They tried to claim at some point that I just have like a Google Drive with every video that I've ever recorded. And I'm just like throwing these out to people like, oh, here's like a link to a folder with every video that I've ever recorded on every, like this is, so I'm being careful to clarify here when they ask me these questions. So he says, so I respond, kind of, although the phrasing of that is strange. I have a Google Drive, and within the Google Drive, you can create explicit links to individual files. So yes, I did not have a Google Drive where it was one link to a folder full of explicit material. Okay, and you would use that Google Drive to share explicit material. I said, correct, I did with plaintiff. He said, so on this post on March 19, 2020, is that the Google Drive you're referring to? I think he puts a screenshot of something out, and I say, yes. And then he stops here. I believe I'm done, Your Honor. Let me just check with counsel, and I'll tender the witness. We'll tender the witness, Your Honor. Thank you. And then the court asks any redirect. And then Andrew, my lawyer, says very briefly, Your Honor. And he says, just a few questions for you, Mr. Bonnell. Since the filing of this lawsuit, have you transmitted the video of you and Pxie to anyone? I said, absolutely not. And do you have any intention to do so? Absolutely not. Well, lastly, you heard Ms. Doe claim that she suffered, a slew of harm as a result of the conduct that she alleges in her complaint. Mr. Bonnell, have you suffered any harm as a result of plaintiff's conduct here in the filing of her lawsuits? Objection, relevance, Your Honor. My lawyer says, there's a balance of equities. It's absolutely relevant. And then her lawyer says, it's not even alleged. And then the court says, overruled. And so Andrew says, again, you could answer and please. And I said, yes, of course, yeah. And he says, can you please explain to the court what harm you suffered as a result of the plaintiff's conduct? And I said, there's a direct monetary loss. There was at least one decently large sponsor that canceled their engagement with me. I believe it was for a low five-figure amount. And again, I've lost the tens of thousands of subscribers on my YouTube channel. I think that the revenue for that channel tanked at least $50,000 or $60,000 over the course of 2 or 3 or 4 months. Reputationally, obviously, this is something that gets dragged out a lot by everybody on the internet. And personally, it amplified all of these videos a ton. And now more people are posting even more of the content. Sometimes people message my minor son, and they send him these videos now. But yeah, it amplified basically everything related to this. Andrew says, thank you, Your Honor. Nothing further. The judge says, you may step down. Thank you. I say, thank you. I should have said, thank you, Your Honor. L. He said, no additional witnesses, correct. Their lawyer says, correct, Your Honor. Okay, and then now the next is just them questioning about some of the other things that are related to the suit. It's going to be the judge talking to her lawyers and my lawyers. Okay, then let me turn to the plaintiff and tell me what, in light of the evidence that we've now gathered, what relief can I enter? Her lawyer says, Your Honor, I believe that the court is empowered to grant the issuance of a temporary restraining order and a preliminary injunction in regards to this case. So how would you write the injunction? And he says, well, how would I write the injunction? Well, the injunction would say that Mr. Bonnell is prohibited from further dissemination of the video, from further directing people to its video until it's taken down, from commenting on the video itself or the images contained in the video while this case is pending. And the judge says, okay, and would it include... Okay, fuck, hold on, I'm just gonna kill my kick stream because apparently it's lagging a lot and the people in chat are listening. Sorry, I love you kickers, just go to YouTube, okay? Kick stream is down. Okay, the idea of the owner of the website, Noel, saying that like he'll take something down, he has no problem with that, but he needs a court order first is ridiculous. I don't know what this, like if you're willing to take something down, just take it down. Why would you need a court order? It's so silly, but whatever. The judge said, and yeah.
Well, Noel is pretty fucking retarded in general. So I figures sponsor, that's 100% the Hospora shekels. Yeah, but then, like, don't people accuse Israel of hiding a bunch of sex criminals? Why the fuck would they rescind that? Just kidding. Okay.
And talking in the subject matter jurisdiction, explain that to me with a little more detail. Their attorney says, well, Judge, with subject matter jurisdiction, what they're trying to argue is that since the original transmission with Rose took place in, they say, April of 2022, and we say October 4th of 2022, that there's no subject matter jurisdiction because Cardi wasn't enacted until October 1st of 2022. So if it happened in April, there was no subject matter jurisdiction. The injunction doesn't have to be issued just by Cardi, although we believe that Cardi, that's the first cause of action in the swing matter, although we believe Cardi gives an ample basis for it because we cited to the Florida statutes that prohibit this as well as intentional infliction of emotional distress. Now, intentional infliction, that requires me to be like malicious, like I'm posting this just to fuck with Pxie, which is insane, okay?
Yeah.
There's other causes of action which would warrant the issuance of the temporary injunction and preliminary injunction in this case. But then we also turn to the issue of the dissemination to LBMC and his direction of individuals to the site where it's being posted. So that's additional dissemination, we believe, under the statute. It's crazy. The judge says, okay, take it a step at a time. With respect to the April issue, you haven't introduced any testimony differently, right? You haven't introduced any evidence at this point that disputes or that directly contradicts the argument that it was European time. And then they say, well, Miss Doe testified that it was October 4th. And the judge says, but she has no personal knowledge of them looking at what she's looking at. And he says, right. And I don't disagree that that's an issue that's in dispute. And the judge says, right. And he says, but, and the judge says, so let's assume that it was in April, just for the sake of argument, assume that the communication was in April, such that the communication falls outside the statute. What injunctive relief or what legal basis do you have for an injunction in any event? Her lawyer says, if that were the case, I would have Florida statutes which provide for the issuance of the injunction as well, Your Honor. You can issue the injunction under Florida statutes as well. And then as a basis, and the judge says, and specifically, which statute? And he says 784049. And the judge says, is there any statute of limitations type problem with the statute applying? He says, I don't believe so, Your Honor. I mean, if it was disseminated in 2022, a four-year statute of limitations puts us at 2026. So there's no issue with that. The judge is right. And he says, but I think even under Cardi, the ABMC declaration, it's a he said, she said at this point as to whether or not she received the video relating directly to my client or not. And I think that would form the basis under Cardi. We also have the statement that was made to my client by the other individual that said that her video had been shared 2 months before the filing of the lawsuit. And that's in paragraph 323 of our complaint. By the way, they've never made that person available to us. We have no idea who that person is. I think they've said now this person deleted their account. We have nothing. This just is like, it's triple hearsay. A person said that their sister said that they maybe had received a video of it. Like, this is so stupid. I think it's just a cute.
I remember when supposedly somebody, like some of the evidence that they brought up, I think that it was just entirely made up. Like, I think there's a very high probability that it was just entirely made up. Like, considering how dishonest Pxie has been during this entire fucking case, there's like multiple like text messages lest someone forget. Because mainly because of how much bullshit there is, like it could just easily be swept under the rug. That there was this text message where it's like, oh yeah, I saw that your sister's grandmother's former roommate sent me this whatever the fuck, and I recognize it as such. Like, you provided all the evidence a lawyer would ever need to know inside one continuous text message in one screenshot. What is the likelihood of something like that happening for a revelation concerning someone's leaked nudes? Extremely tiny, right? Extremely small. And for them to talk specifically in legalese, in a text message, you're using that as evidence? Like, I'm sorry, okay? That is crazy. So the chances of that piece of evidence just completely being fabricated is extremely high. Like, as in, nobody IRL would ever talk like that, in addition to the way that they structured the text message, right? Like, why the fuck would you ever talk like that? Ever. I've never seen anyone talk like that, ever, right? So, yeah.
Farmer emailing her or damning her is my guess.
Yeah.
All we have to do is show competent proof. It doesn't have to be proof beyond a reasonable doubt or clear and convincing evidence. It's a preponderance of the evidence at this point. And given that, we believe that we've put forth substantial competent evidence, which would give rise to the court being able to issue the injunction at this time. And then the judge says, and last question, you learned about the Abby allegation when? And they said, Your Honor, I believe that we learned about it during the course of the lawsuit. And then the court says, so after the lawsuit was filed? Correct. There was one issue that we've considered is whether or not an injunction at this point is stale based upon A, the allegations of the complaint talking about when the dissemination occurred, B, the after-knowledge by the plaintiff of the infringing activity that no effort was made to seek injunctive relief until months later. How do you respond to that? Well, Your Honor, I don't think it's stale at all because the issue arose in November of 2024. That's the first time that my client ever became aware that her video had been shared with anyone without her consent. After that, she made efforts to contact Mr. Bunnell to handle this matter amicably to see if they could be taken down. Mr. Bunnell led her on, told her that he was making efforts, that he hired a law firm, that he hired a private investigator, and he delayed that proceeding. I didn't lead her on. All of these statements are true, but okay. Then the lawsuit was filed within months of that, and the irreparable harm continues. The video is still available. It's still being disseminated. It could be disseminated at any time, and Mr. Bunnell himself could disseminate the video without an injunction prohibiting from doing so. Monetary damages aren't enough or a substitute for an injunction under these circumstances, and the case I cited to the court, the Doe versus Constant case, makes that abundantly clear. So under the circumstances, I think that Your Honor is well within his rights to issue the injunction that we seek. He says, thank you. And then Andrew says, thank you, Your Honor, because I call my attorney up. Personally, Judge Becerra already denied the TRO. That's the main judge in my case. We're talking to the magistrate judge right now, which is another judge brought in to help with cases when there's a high volume basically through the court.
Well, there's always a high volume these days, but
So plaintiff's counsel's argument that the TRO issue is moot, the court has denied it, finding that the TRO
the problem obviously is women.
was stale. Plaintiff found out about these videos in April. It's now June, and she's seeking a preliminary injunction. Judge said, you said April, did you mean? Andrew says, I'm sorry, you meant November. And then he says, November of 2024. It is now June of 2025. The court has already determined that there was no emergency. The court has already determined that the request for a TRO is stale, and so is the request for preliminary injunction. Where is Abby MC? Plaintiff's counsel has represented to me that she was a client of their firm. They said that initially, by the way. Now they've said she's not. I've asked them to accept service of a subpoena on her behalf. No response. We have a hearing in court today where her testimony would be critical. She is nowhere to be found. We have no evidence whatsoever that this court has jurisdiction over this dispute. There is no federal question. The statute that they are suing Mr. Bunnell under did not even exist at the time that the video was transmitted. And this Florida statute that they're suing on for, under a theory of supplemental jurisdiction, because there's no diversity between the parties, requires malicious intent. That's the Florida statute. It requires Mr. Bunnell to have published the video himself onto a platform. He did no such thing. That's why they try to make this argument that when I share a video on Discord, it counts as like a public posting, which is ridiculous. But that's why they keep leaning on that, because they need that for their other claims, basically. These two individuals are part of an online community where they share sex tapes with each other, and it is not out of the question that a sex tape gets leaked. And it is just not something that this court needs to be involved with in terms of issuing an injunction for conduct that did not even occur since the statute was enacted. You've heard from Mr. Bunnell today. He was forthcoming, he was clear, he was honest. You don't issue an injunction based on conduct that took place months ago, or what plaintiff is afraid might happen in the future when there has been no evidence of any dissemination by my client personally at all on any website, and secondly, since the enactment of the statute. So the court not only does not have the authority to issue a preliminary injunction because it lacks subject matter jurisdiction over this dispute, but even if it did have that authority,
Bro, Andrew Brettler is such a real one, on God. Like, yeah, Andrew Brettler is such a real one. But the thing is that obviously it's very expensive to hire his services. But I will say that it's a real one. That's a really good lawyer. Yeah.
Even if there was a scintilla of evidence to show that this video was transmitted, post the enactment of the statute, there is no further conduct to enjoin. There's no conduct to enjoin. Mr. Bunnell testified he is not publishing the video. He hasn't published the video. He has no intention to publish the video. He's taken measures to try and remove the video that other people have published. He himself is being harmed by this. Why didn't plaintiff sue Kiwi Farms? Why didn't plaintiff sue these other websites that have allegedly published the video? Mr. Bunnell doesn't control those sites. Mr. Bunnell can't force Kiwi Farms to do anything. He can ask, but Kiwi Farms is out of jurisdiction. Kiwi Farms is a corporation based in Texas. They filed a motion with this court asking the court to enjoin Kiwi Farms to take down the content, but according to plaintiff's own motion, Kiwi Farms will voluntarily do so. Why do they need a court order? Mr. Bunnell doesn't object to Kiwi Farms removing the content. What he objects to is forcing him to pay for their injunction. That's also a thing that they had, by the way. Forcing him to pay to have the court issue an order, forcing Kiwi Farms, a website he doesn't control or cooperate with, to remove his content. That's what he's objecting to. He's objecting to how arbitrary it is. We submitted a link of, 26 URLs of other content that Kiwi Farms is posting in addition to this video of plaintiff and Mr. Bunnell. They absolutely refused to ask Kiwi Farms to remove that content. This is one of the, it's a long time ago, but this is one of the most disgusting things that Pxie has done. I don't know if she's pro-revenge porn, if she thinks men don't suffer from revenge porn or whatever, but she refused to have me, because she basically said, here, how about we take down everything relating to me? Here's 4 links, can we do that? And my response was basically, okay, sure, but if we're gonna make a court order taking things down, can we just take down every lit video? And they were like, no, I just want my stuff taken down. Not any of the other women, not you, just my stuff. If you want everything taken down, then you have to pay my court costs. Fuck you.
Oh
How
my
fucking
God.
disgusting. What a disgusting and gross thing to try to make a demand of. It's so, you claim you care about the other women harmed in the case. Obviously you don't give a fuck about me because she's on her woke yes queen hate men arc or whatever, but Jesus Christ. But anyway, they absolutely refused to ask Kiwi Farms to remove that content. They're focused on this one little video. And if Kiwi Farms and this guy named Noel wants to remove the video, God bless him, we hope he does. He doesn't need a court order from a district judge in Florida to tell him to take down the content. He should just take it down. And and that again, all assumes that plaintiffs can even meet their threshold showing of subject matter jurisdiction here. The court does not have the authority to act in this case, period. That's what the judge ultimately agreed with. It just doesn't. The case should be dismissed. Oh, no, wait, I'm sorry. They haven't agreed with this. They just, that's not true. Sorry, I misstated there. Doesn't have the authority to act in this case, period. I thought he meant in this case as in the case of the preliminary injunction, but he means in the whole case. It just doesn't. The case should be dismissed, and they have had every opportunity to show that subject matter jurisdiction lies, and they failed. And the judge asks, why is there no diversity? Where are the people from? And Andrew says, they're both here in Florida. And the judge says they're both Florida people. And then Andrew says, yes, they're both here in Florida. There's no diversity jurisdiction. This is a federal question case where they've tacked on state law claims that they have absolutely no bearing on this dispute, because they have different standards. They require malicious intent. They require an extortion element. They require posting directly onto websites. Mr. Bonnell did none of that. The judge says, where do you get that, by the way? And then...
So was it Shame or Money that brought this to court? It's almost 100% spite. Yeah. It's just pure spite and disgust and revenge. And she was probably getting egged on by Lauren De Laguna, who fucking hates Destiny. And she was also probably getting egged on by all the anti-fans who are probably gassing her up and glazing her for, pursuing this of Destiny. So there's like a lot of aspects here that just are conjoined.
My lawyer says in the Florida statute, and
what can you
the
do?
Judge says, yeah. And Andrew says, we did a lot of research on Florida case law that seemed to require malicious intent by the defendant. Malicious intent to cause harm to the plaintiff financially, etc. And all of the local cases, the Florida state cases interpreting that statute, focused on the malice element. There is no malice here. There's been no showing of malice, but more importantly, there's been no showing that there's been any transmission post-effective date of CARDI, and the case should absolutely be dismissed at this early stage. And the judge
Pxie just seems kind of evil. No kidding.
says, because if he were in state court, the court couldn't join it because he didn't post, or couldn't join it because he didn't post on an internet's website, but he disseminated it through electronic means. And Andrew says he disseminated it to Rose back before the federal statute was enacted. The court says, right. Andrew says he did not do so with malicious intent. He never identified plaintiff by name, never identified plaintiff by screen name, never said, this is so-and-so, you should, here's a video of her, never to cause her harm. They're part of a community that enjoys sharing sex tapes with each other, and they publish them online. It might not be normal for us or for the general public, but it is certainly normal in their community. And there was no evidence that Mr. Bonnell did anything to harm Pxie, to harm the plaintiff. He, in fact, immediately expressed that he was upset that the video was published outside of his control. Clearly, there was someone that hacked Rose, or Rose, published this material on his or her own. We don't know who Rose is, but it's not Mr. Bonnell that had any malicious intent to harm plaintiff. He's harmed by this. Mr. Bonnell is the one who's the victim of revenge pornography here. We heard testimony earlier today about the website crashing because of Stephen Bonnell's quote-unquote blowjob video. It was a completely different video that had absolutely nothing to do with the plaintiff that crashed the Kiwi Farm site well prior to this lawsuit even being filed. It had nothing to do with the plaintiff. That video that crashed the site was from Mr. Bonnell and another sex partner, and it got a lot more views than any video that that ever wound up being published of him and the plaintiff. And those videos that were published of him, the plaintiff had, certainly did not originate from Mr. Bonnell's transmission. That's the bottom line. This court doesn't have jurisdiction to enter the injunction that they're requesting, and there's no conduct to enjoin. There's just no more ongoing harm. Why are we here in June if this alleged conduct, if this allegedly caused plaintiff to feel suicidal in November? It doesn't make any sense. And the judge asks the other lawyers, do you want to reply? And then her attorney said, briefly, Your Honor. As far as the staleness issue, the issue relating to a temporary restraining order as opposed to a permanent injunction are two different standards as far as the time frame is concerned, and the Doe versus Constant case makes that abundantly clear because the permanent injunction was issued months after the conduct took place. In that particular case, the disclosure of the materials took place in August of 2023, November 2023, and January 2024. They filed the lawsuit, and it wasn't until July 23rd, 2024 that the permanent injunction was issued. So that addresses one of the issues as far as staleness is concerned, and then the court also says the court can see no harm to defendant in foregoing further distribution or displaying of plaintiff's intimate photographs. On the converse, the court can foresee a great deal of harm to plaintiff should the intimate visual images of her continue to be disseminated. Accordingly, the balance of equities weighs heavily in favor of an injunction, and there's no harm for the public in granting the requested relief. So, Your Honor, I think that this case is on all fours as it relates to almost the same set of facts that are applicable on this particular case as far as the time frame when our client knew or should have known that this has been posted and disseminated. As far as Kiwi Farm's argument that they're positing, it's just bootstrapping to their argument on subject matter jurisdiction, which is more than adequately a Strapbush, through the ABMC declaration in paragraph 23, adequately established through the ABMC declaration in paragraph 23 of our complaint. Even if we were to put aside the issue of whether or not the initial sending of the video was in April as opposed to October in this matter, accordingly, Your Honor, and then the judge stops and says, did you allege the ABMC incident in the complaint? Ooh, they did not. No, Your Honor, it wasn't part of the original complaint. It's part of the evidentiary submissions in this case, but we do reference paragraph 23, which is the other attempt that he made to disseminate it to another individual a few months before this lawsuit was filed. And also, Your Honor, and then the judge says, and what evidence do I have of that? What evidence do I have of that? And then their lawyer says, well, she testified as to that today as well, Your Honor.
As a law student, the lack of prep was confusing. I think maybe Pxie's lawyers are just thinking of this as like maybe they do this regularly. I think I want people to just look into Pxie's lawyers. These people who should have everything prepared ahead of time. Like, someone needs to look into the way they conduct their cases, because if they conduct every single case like this, then I wonder if they're cheating people of their money, maybe somehow, by promising that they are able to fight the case, but in the end lose it. I'm not entirely sure. I don't even know if it's the law firm itself. I honestly do not know if it's even the law firm itself. Maybe it's the specific lawyers. I'm pretty sure the lawyers are supposed to pass the shit to their firm and figure out whether or not it's worth going after. Yeah, I guess I just don't know. The lack of prep turned the legal HIV of this case into full-blown AIDS? Sure.
that she had had contact with an individual that had received the video from Mr. Bonnell to her sister, and hearsay is admissible. This would be double or triple hearsay, by the way. And hearsay is admissible in this type of proceeding, and you can give it the weight that you believe is appropriate under the circumstances, given Mr. Bonnell's proclivities for disseminating videos on a very constant basis. Also, Your Honor, I think that it's important to note that he has been continuing to make it accessible vis-a-vis Google Drives, so it's an ongoing dissemination as long as it's being disseminated or accessible on his Google Drive, which were posted publicly. That's not true. That's a fucking lie. This is, response to his argument that I can't rely on the statute because there's been no evidence of malice in the dissemination. And then this is the dumbest argument that they try to roll with. Your Honor, at any time that you violate somebody's trust in this fashion, there is malice. He knew that he didn't have the authority to disseminate it, and therefore it's malicious. It's not, he didn't say, oh, well, I texted it by mistake. I didn't intend it to send it to Rose. It was, I hit the wrong button. That's not anything that he's testified to. He sent it deliberately. And that, in and of itself, is malicious when you are sharing the intimate graphic details of a sexual encounter that you have no right to share with a third party without the consent of the other individual. I think malice is implicit in what Mr. Bonnell did in this particular case. And then the court says, well, the statute says that you have to disseminate through electronic means. And then her lawyer says, he texted it. And then the judge says, a sexually explicit image of a person that conveys the personal identification information of the depicted person. What does that mean? They say, Your Honor, I think can the person be identified as a result of the video that's been disseminated? The case law isn't clear on that, but what we do know is that numerous people, even the testimony from Ms. Doe, is abundantly clear that everybody could identify who she was, and they were posting about it, they were texting her about it, they were DMing her about it, so it's clear that it was her. So I think it's that sufficient to meet the criteria under the statute. And then the judge says, then the next provision says, with the intent of causing substantial emotional distress to the depicted person. And then her lawyer says, Your Honor, so whenever you do that, oh God, this argument is so scary. Your Honor, so whenever you do that, you know that the possibility, well, not just the possibility, that it will cause distress of the other person, to the other person if that does come out. And we have the testimony of Mr. Bonnell himself, who says that there's no secrets on the internet, okay? And he also says,
I like how when it comes to all these arguments, like Destiny is supposed to have like infinite foresight. Every single time he shares nudes, every single time he trades it with someone, he has to anticipate somehow that this was going to be leaked all the way through, like literally all the way through. Like, what? Like, you could have anticipated this all, like, whatever the fuck. Bro. It's crazy. Actually unhinged.
said that posting without somebody's consent is one of the worst things that you can do, and implicitly it's because we all know that that's going to live in cyberspace in some form or another for eternity, and that's going to cause the distress of that particular individual.
So
and the judge says, well, I guess their defense is that his quote-unquote community that she participated in are basically people who routinely do this, and so therefore, even assuming that he made a mistake about what he believed to be her consent, let's assume that he didn't do it with the intent of causing her distress because he thought that she was part of his community. So this is funny. They're trying to shift.
The Cardi law is about sharing, so he doesn't need any foresight, only consent, surely. I don't fucking know. Like, the Cardi law, like, I think implies that there has to be motivation and malice, right? By the way, like, they haven't presented any evidence in the first place, so it's like, what? Yeah, I don't know. There's not even any evidence in the first place to even present.
Shift the intent of that statute to a different part. The intent isn't whether or not you had consent to do or not do a thing. Even if you don't have consent, the intent part is you intend to cause them emotional harm, right? And they're making this like per quad argument of like, well, anytime you do it, obviously there's an intention to cause harm, but that's not necessarily true. That's stupid. You could like share an intimate video or picture of somebody, even if you know that you're not allowed to, but you're still not intending to cause harm to that person. You could just be gooning or whatever you want to say, right? Like there's not that the intent part isn't on like just the did you send a thing, right? And then their attorney says, the problem is the internet isn't relegated to just his community. The internet is the public at large. So, and the judge says, but he didn't post it on the internet. He sent a text message. And they said, I understand, but, and then the judge says, because it would be different if he posted it on, say, a Substack, right? Now, I don't know if the judge was like referencing kind of snarkily the fact that she made a Substack talking about all of this or not. I don't know if that was the intent there or not, but that was, I don't know, that's kind of a funny line from the judge. And then her lawyer says, well, he has, and then the judge says, but if he sends a text message to an individual, and then that individual either disseminates it without his consent or gets hacked, the question is that what the statute is going at? In other words, is that what, why would you
consent or malice is not there? Well, that's up to the judge to interpret, right?
have if you post that on an online community, knowing that millions of people or thousands of people are going to see it, malice can be presumed at least, right? At least in the initial stages. But in a situation like this, how do I know that? And they say, well, Your Honor, there was no caveat whatsoever that Mr. Bonnell had placed on the dissemination of that video with Rose. He didn't say this can't be shared, this can't be posted. And then the judge says, well, even if he did, it wouldn't have mattered because if it is true that she was hacked, right? This other person, Rose, any of those disclaimers, any of those caveats would have been made irrelevant. And the lawyer says, well, and that's what we're assuming based on his testimony is that they were hacked. We don't have any evidence. And the judge says, right, we don't have any evidence of it, right? And then their lawyer says, of course, at this time. And the judge says, right. And then their lawyer says, but we do know that he disseminated the video without consent, that he knows.
You cannot seriously think that? Well, I mean, what's more important, right? Like what the Cardi literally says, or the judges or jury, like, or the court's interpretation of it. It's like, oh, would you evaluate something based on the law, or would you evaluate based on the precedents of that law, right? Because the precedents could entirely redefine how law is interpreted. Like, yeah. What exactly is the point of what you're saying? But I get it, okay? People kind of have to bend themselves over into knots to try to get Destiny to be guilty, and they're just coping their entire way through. I get it. But, like, that's what I mean. Like, why is the judge skeptical? Like, don't argue with me, argue with the judge, right?
That in and of itself, that person can do whatever they want with that particular video. They can send it to everybody in their group chat. They can post it online. They can do whatever they want with it. And in and of itself, knowing that could happen, knowing that, as he says...
Okay, I'm going to ban you. But after you're banned, I'll explain very briefly, okay? So you're probably listening still now, okay? But basically, in court, we have laws, all right? However, the way these laws are governed or determined or ruled upon is based off of precedents. What is precedents? When a court rules on a law, they have to look at previous court cases that use that same law. You cannot contradict a prior ruling when you're interpreting that law. Because if you contradict, that's not good. You're supposed to have the same consistency all the way through. That is called precedence. Do you understand what precedence is? Oh, Lamau, he's a JStock mod. And you're a former JStock mod. Boom. So when it comes to Cardi, even if there was no precedence, I feel like it has to be beyond this case, right? I'm sure there's like cases that have used Cardi before, no? Yeah, there is precedence for sexual harassment online. Not specifically regarding Cardi, but in terms of other cases that have existed before Cardi. In a civil case in Tampa, I believe Tampa, Florida, right? Melissa Berry was awarded $600,000. Holy shit. After her ex-boyfriend posted nude pictures of her online and sent them to her mother. Okay. A Tallahassee man who hacked into dozens of women's accounts to steal private photos and post them on revenge pornography websites was sentenced to 10 years in federal prison. Bro, online people are so insane. Dude, Florida is so fucking nuts, dude. Like, how is this anywhere close to Steven's case? Dude, these are crazy. Like, these are crazy.
Nothing is secret in the streaming world per se. He knew that this was reasonably foreseeable, remember that word, foreseeable, and highly likely that at some point this was going to get out, and he had no regard for it. And he's had no regard for it in any of the time for the sharing of any of these videos. And then the judge accurately says, but if that were true, then she's guilty of cyber harassing because she sent a video of her former boyfriend. So if it was true that simply putting it out there is sufficient, right? Because once you disseminate, bad things can happen, then she would be guilty of it. She may not have had any intention of causing substantial harm or emotional distress to her former boyfriend because she assumed that she had consent, but she clearly disseminated it. So how is that any different? And then her lawyer says, well, the difference is this, Judge. I think it may have been lost in her testimony, but she had consent from her boyfriend to disseminate that video. So he knew what he was facing, what the reasonable foreseeable consequences of that were, and what could happen with that particular video, and he consented to it. The difference here is that she did not consent dissemination of the video that she made with Mr. Bonnell, and that is the crux of the difference in these two scenarios. And the judge says, sure, because if in fact she didn't consent, then it makes a difference. The question, though, for me is, for purposes, well, that's a different issue. If she didn't consent and he violated their trust, then number one, you have a contractual arrangement, theoretically. Number two, you have at least a negligent infliction of emotional distress. The statute seems to require, to me, to find that at the time of dissemination, he did so with the intent of causing harm to the depicted person. So, do I have enough evidence at this point to make that finding? So negligence is different than malice, right? So let's say that I'm like sending videos to a bunch of people because I'm gooning or whatever. You could argue, okay, well, you're being negligent here, but the statute that they're citing requires malicious intent. Like, I'm not doing this with disregard.
Holy shit. Okay, fuck. I wish I could unban that one JStock mod. Fuck me. Wait.
Well, the difference is this.
Oh, we need to go. We need to go over this last part. Absolute cinema.
In any of the time for the sharing of any of these videos, and then the judge accurately says, "But if that were true, then she's guilty of cyber."
It's funny as fuck. This JStock mod joined the server to argue with me.
harassing because she sent a video of her former boyfriend. So if it was true that simply putting it out there is sufficient, right? Because once you disseminate, bad things can happen, then she would be guilty of it. She may not have had any intention of causing substantial harm or emotional distress to her former boyfriend because she assumed that she had consent, but she clearly disseminated it. So how is that any different? And then her lawyer says, well, the difference is this, Judge. I think it may have been lost in her testimony, but she had consent from her boyfriend to disseminate that video. So he knew what he was facing, what the reasonable foreseeable consequences of that were, and what could happen with that particular video, and he consented to it. The difference here is that she did not consent dissemination of the video that she made with Mr. Bonnell, and that is the crux of the difference in these two scenarios. And the judge says, sure, because if in fact she didn't consent, then it makes a difference. The question, though, for me is, for purposes, that's a different issue. If she didn't consent and he violated their trust, then number one, you have a contractual arrangement, theoretically. Number two, you have at least a negligent infliction of emotional distress. The statute seems to require to me to find that at the time of dissemination, he did so with the intent of causing harm to the depicted person. So do I have enough evidence at this point to make that finding? So negligence is different than...
Okay, so the judge is literally requiring malice. Bro, the judge is literally arguing for evidence of malice. Are you actually fucking kidding me? What? Wait, did he leave? Dude, he fucking left the server. Coward. Coward behavior. Coward behavior. He left the server. Oh my god. Coward behavior. Coward behavior. JStuckMod. JStuckMod. Coward behavior.
malice, right? So
dude, bro did not want to contend. Bro did not want to contend.
let's say that I'm like sending videos to a bunch of people because I'm gooning or whatever. You could argue, okay, well, you're being negligent here, but the statute that they're citing requires malicious intent. Like, I'm not doing this with disregard for the plaintiff. Maybe you could argue that malice could rise if I post it to a website public. Well, he barely knows this person. He doesn't know Rose from a hole in the wall is basically what he's saying to you, Your Honor. He's known her for a couple months, talked to her on DM, and well, here's this private information about an individual that you know nothing about. Do with it what you will. There's no parameters to it whatsoever. And, he's using it to entice her maybe into the next sexual encounter. But to that, as it may, he has a habit of doing this, Your Honor. It's not the first and last time that he's done it. So this, by the way, this hurts your foreseeability argument, because if you're saying I've done this multiple times and it's never leaked before, well, how is it reasonably foreseeable that this would be leaked? Like, you're arguing against yourself here, right? So I think that the malice is there, and I showed Your Honor the text messages leading up to the encounter where she indicates that she doesn't want anyone to know that they're engaged in a sexual relationship of any sort at the time, and that she trusts him and that he understands what consent means. He tries to spin it in a different direction, but I think it's abundantly clear what the purpose of that text was, or what the purpose of that Discord post was at the time that it was sent to him. The fact that he now wants to say, well, I thought I had implicit consent or some type of implied consent, implicit or some type of implied consent, flies in the face of what he received. So I think under the circumstances that you have a number of ways that Your Honor is empowered to grant the permanent injunction in regards to this particular case. The judge says, okay, all right, I'll take that all under advisement and issue out a ruling soon. Their attorney says, thank you, Your Honor. Andrew says, thank you, Your Honor. The court says, now I will say this. I'm not going to ask for it. There's some intersection between what we're dealing with and what's happening since, because, for example, I was going to say I wanted to grant the injunction and I felt that I had a good basis, or that I had a beat basis to, I don't know, and all the elements were met. Theoretically, that would include potentially mandatory injunctive relief, but that's relevant.
We're almost done anyway, okay? Thank you so much for the 50 kick points, Corey.
Also to the pending motion on the Kiwi Farms thing. So there may be some overlap there, so I may consult with Judge Becerra about how we should handle that to be more efficient on our end, but I would take it a step at a time first, because obviously if I conclude that I can't grant the injunction legally, then there's no overlap. At that point, then the other issue still stands that needs to be taken up on its merits. Andrew said if they want to add Kiwi Farms to the lawsuit, then that's their prerogative. But right now, the only motion is for an injunction against Mr. Bonnell, and we've demonstrated that they haven't met their burden. Thank you, Your Honor. The judge says thank you. I'll rise, and then that's it. Jesus. Ugh. Anyway, that was their hearing. Obviously, I think this hearing was a disaster for them. The fact that they lost, this was what the ruling a few weeks or maybe a month ago was about. All of this preliminary injunction request failed on all four elements. It only has to fail on one, but it failed on all four. Yeah, what a meme. I might post the transcript publicly. Obviously, I have the whole PDF, but I don't know what the norms are. Oh, the C is Becerra. It has an S sound. Oh, Becerra. I can't remember. It's Becerra, whatever. Sure. Since you went live, they also filed another reply to their Hague filing. I need to leave. I've been streaming for too long anyway, but October 27th. Oh, that's today. 157 docket items. Oh, they're trying so hard to subpoena Molina, but it's like, bro, you guys
subpoena
are
Molina.
So anything with Molina would have been way before the statute date. I don't know what you're hoping to get out of her. The fact that you're trying to drag her into this so late. Why wouldn't you file the subpoena months ago? Why are you trying to use an international convention to do it's so late? It's so late. You've fucked yourself. Yeah. Destiny, the transcript is on the docket. The whole transcript is posted now? Or are you just lying because you think that the
Absolute Cinema, Hague Convention,
is the same as the transcript itself?
Try her at the Hague.
Okay. Is it over now? It's still ongoing? Nope, it's still ongoing. They're trying to drag it out as far as possible. Oh, the full PDF is there. Thank you. Nice, spaced. Okay.
Wow.